Welcome everyone to the second of 3 events on the rule of law and combating systemic discrimination. I am Professor Errol Mendez, the President of the International Commission of Jurists Canada, established in 1958 by the legendary Chief Justice of Canada, Ivan Rand, and other former judges, lawyers, academics, and human rights champions. At ICJ Canada, we seek to promote greater understanding in Canadian society on the substantial demands of justice, human rights, and non-discrimination in the operation of our laws and institutions. Given the challenges to the rule of law that we have seen, not only in other democratic countries, but also in our own society, in the areas of policing, the criminal justice system, and corrections, you will admit that it is a worthy goal for an organization to focus on. We encourage the participants today to join us in this endeavor and become active members of ICJ Canada. I encourage you and those in your networks to check out what we have done and are doing in promoting the rule of law at our website, www.icjcanada.org. And for those who are already not members, we welcome you to join online. It's very easy to do so. Today, we are focusing on judicial proceedings. And in our final of the 3 events, we focus on corrections on May the 17th, 2021. Before I introduce the moderator for this panel today, David Antonyshyn, and our executive director, David Hebb, I want to give a land acknowledgement for this virtual meeting. I would like to begin by acknowledging the Indigenous peoples of all the lands that we, who are on meeting online from across Canada, are on today. I would like to acknowledge that the land on which I and several of the participants in the panel today are speaking from the traditional and unceded territory of the Algonquin Nation. While we meet today on a virtual platform, I would like to take a moment to acknowledge the importance of the lands which all the participants in today's events each call home. We do this to reaffirm our commitment and responsibility in improving relations between nations and to improve our own understanding of local Indigenous peoples and their cultures. From coast to coast to coast, we acknowledge the ancestral and unceded territory of all the Inuit, the Métis, and the First Nations people that call this land home. Please join me in a moment of reflection to acknowledge the harms and mistakes of the past, and to consider how we are, and each in our own way, trying to move forward in a spirit of reconciliation and collaboration. Now, briefly for the introduction of the moderator for the panel today and our executive director. In November 2018, David Antonyshyn became one of 2 deputy directors of the public prosecutions with the Public Prosecution Service of Canada, which is responsible to prosecute cases under federal jurisdiction across Canada and to provide legal advice and assistance to law enforcement. David previously served for 28 years in the Canadian Armed Forces, at least 20 of which in a number of positions within the Office of the Judge Advocate General, the legal advisor to the Canadian Armed Forces and the Department of National Defense in matters of military law. Prior to retiring from the forces with the rank of colonel, he was the deputy JAG, leading the legal division, assisting the JAG in superintending the administration of military justice in Canada and ensuring its responsibility for development within the broader Canadian justice system. He is, I'm proud to say, also a valued ICJ board member. David Hebb, our executive director, who will be monitoring today and be able to respond to any problems we have on this virtual meeting, is an accomplished young lawyer, presently completing his professional legal qualifications, working with the Military Police Complaints Commission. He is a graduate of the law faculty at the University of Ottawa and is completing a master's degree in law. He has also been a legal advisor to members in Parliament. David, over to you. David Antonyshyn, over to you to start this panel.
Thank you very much, Professor Mendez. Welcome everybody to this second panel in a series of 3. I will mention it at the end, but I'll mention it right now. On the May 17th is the 3rd and last panel event of that series, focusing on the corrections and of the justice system spectrum. So again, shout out for this event. Today, I'm excited and honored to be joining you from wherever you are across the country, from the comfort of my home, and join with fantastic panelists. There are incredible individuals and jurists. They will bring perspective from three of the most fundamental positions, if you will, functions in our justice system: that of a judge, that of a defense counsel, and that of a prosecutor. They will share their insights based on their vantage point and also their experience. I will briefly tell you who they are. We have Rob Dhanu, who is joining us from the West Coast today, former Crown prosecutor, currently defense counsel. He will get into his experience, so I don't want to steal any of his thunder. He is bringing a very interesting perspective, and hopefully you will enjoy, as I have in the last few months, my discussions with them and the rest of the panel.
I cannot hear what he's saying.
Am I muted?
No, I can hear you, David.
Okay, thank you. Sorry about that. It shows that I'm live. The other panelist we have is my current boss, fantastic person.
Not sure what happened, but I cannot hear.
Fantastic boss, David Hebb. If you can try to help Judge Morin, that'd be great. Kathleen Roussel is the Director of Public Prosecutions.
Cannot hear what he's saying.
Deputy Attorney General of Canada. She is at the head, as Evel mentioned, the organization where I work. She's at the head of that organization. 1,000 people working across the country. We share a responsibility with the provinces for prosecution of criminal cases, and we are the sole prosecuting authority in the three territories. So Kathleen heads that federal prosecution service from coast to coast to coast. And we have Judge Morin, who is a judge in Saskatchewan, but also in two of the three territories. He has a fantastic background. You can read from his bio that he was a professor before becoming a judge. He was also working with the justice system, within the justice system, but not as a lawyer, not as a judge. You will hear from his perspective as well. And he was the first, and he will expand on that, but the first person to actually run the trials, complete trials in Cree language, not through translation. So what we will do today is, when I'm done talking in a few minutes, we will begin with having introductory remarks, comments from each of our panelists. That will be followed by a conversation. We will welcome your questions using the Q&A button at the bottom of your screen or on the side of your screen, but to me it's at the bottom. If the questions are coming in during the conversation that our panelists will have after the introductory remarks, and if those questions make sense, given where we are in the conversation, I will try to be your voice and inject those questions in the conversation. If, on the other hand, the conversation is lively enough, and I suspect that it will be lively, I know it will be, the questions may be, or in part, left for the end. We try to leave at least half hour, but it may just be weaved through the conversation. So if you have a question that is directed specifically at a panelist, please indicate so. If it's an open question for the entire panel, I will deal with that accordingly. So just a few remarks just to set the stage for the discussion today. And I just mentioned that these are my observations. They're not that of the Attorney General of Canada, the Government of Canada, the Public Prosecution Service of Canada. They're my comments, my observations, but it gives you a sense of why we brought those people here today, at least from my perspective. I will start by saying that in his book, 2008 book, Malcolm Gladwell, the book Outliers, he talks about success, and what makes success is not, as many people would think, that just the value of that one individual heroic person. their merit, their intelligence, their innovation, and so on. It explains something in part, but there's a more broader environment in which those persons were born and in which they lived, and includes the family, the education they received, the surroundings they had, and a whole bunch of other forces that are way beyond what any individual can control themselves. So that puts things in perspective in terms of how you understand success. And for instance, if you grow up with access to computers, well, you have a head start on becoming fluent with computers, becoming maybe a programmer, as opposed to a kid who doesn't grow up with that access, for instance. Now, if you multiply that by thousands of people, if you have thousands of people who have access to some things, there may be more chances that out of that group, some success will arise in a given field, for example, computer. And he gave the example of somebody who was born in 1902, who will grow up with the pandemic of the Spanish flu, which killed, unfortunately for them and for us, more people than the current pandemic, but 10% of the population. You grow up with that, you hit your adulthood with the Great Depression, and then when you hit your 40s, then you have the Second World War. Things are not the same if you're born in 1930, same family, same values, same background, but then you have a whole bunch of different opportunities and adversity that is not present, and you will grow up in your adulthood with a greatest economic boom in history, recent history. So things are beyond your control to explain your success. Some of the things are beyond your control. So if it's true for that, it must also be true for failure or absence of success. Systems, environment have an influence on how individuals will live their lives. Some individuals are able to go against the odds and succeed despite them. On the aggregate, this is where your environment tends to produce some results in more higher frequency than not, right? In the courtroom, we see that dichotomy in a sense, because the dichotomy between individual responsibility and the environment and the impact the environment has on individuals is, in court, what you will see is a focus on the individual responsibility, the blameworthiness of someone's action, and whether or not that person, beyond a reasonable doubt, was guilty of the offense. And then, if found guilty of the offense, how that person must receive an individualized sentence that is fit to their state of blameworthiness. In our laws, in our system, and the system created to enforce those laws, there's still a high element of morality. Some offenses reflect a moral version of society towards certain conduct, and the idea of we're going to weigh your blameworthiness and give a sentence that is proportionate. Very Judeo-Christian influence in our mindset is in our justice system. So when we look at the justice system, what goes on in the court is part of the justice system, and that justice system is part of a connection of other systems, the health system, the education system, which together form the system, which is a reflection of what society is, what society wants, and in turn, that system influences society and shapes it, and there's a cycle, and eventually it evolves. But there's a symbiotic relationship between the system and the rest of society and society and its system. And when an individual fails to abide by the rules of its society, that person will be brought in the justice system. And then we will look at that person individually. And I would put to you that it would be, intellectually at least, a mistake to disconnect the environment in which that person comes, from which that person comes, and just look at what that person has done, because it's incomplete. Now, that distortion, that delta, in some cases might be of little importance. Sometimes, it may be that, but the crime is so, the facts are such that the part of what the system brought in, or the environment influence, might be minimal. But that distortion accumulates case by case by case by case by case. And if you do have a certain environment that creates that distortion, then you could see effect on the aggregate. So if you have an environment that puts people at a disadvantage, and if the system itself contributes to that creation of that environment, you will likely see more and more results. Now, the justice system is also not just receiving people who have been influenced by their environment. The justice itself injects influence into the overall system and environment. So we need to step back, I would suggest, and look with clear eye as to how it operates. And sadly, we have to factor in historical facts that the system, not just in Canada, but across the world, the system and the justice system has been used to achieve some ends, sometimes purposefully, sometimes by happenstance or by consequence. And it could be done in a time and an era where things are acceptable that are not acceptable anymore. But the consequences the environment created then has lingering effect. You think about trauma that is passed from generation to generation, for example, financial disadvantages and so on. Even if the mindset has changed, the consequences still linger, and still have an effect over time, especially if your system still contributes, even if it's not the overt purpose, but it still contributes to exacerbate and maintain some of those conditions. That's the system within the system, what we're talking about when we're talking about systemic effects, discrimination, racism, and so on and so forth. That's how I perceive it. That's how I understand it. So today, this conversation fits into an effort to challenge the status quo, as in their own way, each of the participants today, each of the panelists have done and continue to do. It's a call to courage, if you will, for you to see what you can do, given who you are in life, to challenge that system and to make it better, to be reflections of society. Because, and I will leave you with that, if it's true that the system can influence the environment in a way that is negative, the corollary is true, can also be used to achieve positive ends. So with that hope and that call for courage and challenge to action, I will give the talking stick, I will give the floor to Rob Dhanu. Rob.
Thank you very much, David, and good morning and good afternoon, depending on where you are, from coast to coast to coast, of course. Thank you. I would say it's great to be here, but here is simply my office where I spend too much time as it is. So I can say that it's great to be here with you. Thank you for joining us on this very important topic. Thank you, David, for organizing this topic. It's pertinent, it's relevant, especially considering what's going on in the world these days. So it's great to have individuals like you doing this important work. And thank you, of course, to my fellow esteemed panelists, Judge Gerald Morin, as well as Kathleen Roussel, amazing individuals and professionals in their own right. In terms of my discussion, it will essentially be through an immigrant lens, but it will also be through the lens of someone who has had a certain amount of privilege and power as a prosecuting Crown attorney, as well as a criminal defense attorney. The best way I thought to frame my part of the discussion was simply to take you through my own journey, both on a personal level and a professional level, in terms of how I came to even begin to understand what systemic discrimination means. It's taken me, I can say, fairly a lifetime to even touch upon the tip of the iceberg of what systemic discrimination is. In terms of systemic discrimination, as I see it, it's something that lurks just beneath the surface of our institutions and our society. It is a concept where we often see the symptoms, but we rarely see the root causes. It is what I would describe as a multi-headed hydra, which is pernicious, but at the same time, invisible. It invades the way we think, it invades the way we act, and it invades our values and how we see and look upon the world. To recognize systemic discrimination, which for me has been a lifelong journey, even being an immigrant, even seeing the world from a different lens, you have to really change your worldview. You have to change how you act. And that's why it's so difficult. It's very difficult to change how you think. It's very difficult to change how you value society and different aspects of what we do each day. And of course, systemic discrimination is tough to grapple with because it means different things to different people. And to some people, it means nothing at all. It's a threat when you say those two words in tandem. So it's a nebulous topic. It's a tough topic to grapple with. And that's why I thought perhaps just sharing my journey would be the easiest way to connect with you in terms of systemic discrimination. And I'll begin with that in terms of my journey of understanding. I grew up in an immigrant family with a very black and white view of the world. My parents came to this country for a better life, and they wanted to embrace the values of Canada, and they wanted to embrace the laws and the rules and all of that. And that's what we were taught growing up. There was good guys, there were bad guys, there was white hats, and there were black hats. My father used to love Western movies, and even in those Westerns, you'd see the cowboys and you'd see the Indians, and you knew who the good guys were and who the bad guys were. And what kid, what child does not want to be on the side of the good guys? Who doesn't want to wear the white hat as opposed to the black hat? And so with this type of thinking ingrained in me from a very early age, I decided I wanted to become a police officer. I wanted to be a member of the Royal Canadian Mounted Police. I wanted to wear the red serge, and I wanted to put bad guys, quote unquote, in jail. That was my calling, I felt. And I never thought in a million years that I could ever defend or be on the side of bad guys, which of course is what I do now today for a living. I thought anything of that nature would be just absolutely outlandish, absolutely crazy. So when I look back on my understanding and how I came to have some understanding of systemic discrimination, I look back in those early years first. What is systemic discrimination? It is something that becomes a part of your DNA from a very early age. It is the values we are taught in our own households. It is the specific window we are taught to gaze upon the world from a very early age. And it's about seeing the world in a very black and white way. There's good guys, there's bad guys, there's us, and then there's them. There's criminals and there's law-abiding citizens. And certainly I grew up with that very black and white mentality. And so as I went through undergrad at Simon Fraser University and decided I wanted to still have that thought of being a police officer, I realized I wasn't quite ready to get into the real world, have a mortgage, have a real responsibility. So I thought, what's the next best thing to being a police officer? And I thought, okay, well, Crown prosecuting attorney. So I ended up going to law school, and that was the path I embarked upon. Now, in terms of my Crown prosecution career and how that impacted my understanding of systemic discrimination, I worked at the Department of Justice in Vancouver, 222 Main Street, which at that time was probably the busiest courthouse east of Toronto. It's also right in the heart of the downtown east side of Vancouver, next to probably the biggest open air drug market in Canada. Now, for an immigrant kid from the suburbs going into this venue, it was, I can say, quite a shocking experience. I witnessed essentially what seemed to be third world conditions in a first world country. And as I walked those cobblestone streets of Gastown to the courthouse, I looked around wide-eyed. I noticed that many, perhaps even the majority of the faces that I saw were Indigenous. I noticed that addiction and mental health clearly appeared to be significant issues in this area. But everyone was walking around as if there was nothing to see. Everyone was walking around as if this, what appeared to be a war zone, was the most normal thing in the world. And then after a while, so did I. I just became used to it. It became part of my daily routine. And so when I look back on my thought process and I ask myself, what is systemic discrimination? It's the acceptance of the status quo, no matter how horrible it is when viewed objectively. because when you accept it, you then normalize it. And that's exactly what I was doing when I was embarking upon my career as a prosecutor. But I felt deep down inside of me, something seemed wrong. Something didn't quite add up. I had a feeling that this is not right, although it didn't quite reach my thought process at that stage in a full manner. So I began my job as a Crown prosecutor. I'm bright-eyed and bushy-tailed, prosecuting primarily drug offenses, firearms, those kinds of things. And I felt I was really doing my calling. I was the good guy. I had my white hat on. I was putting the bad guys in jail. And my typical day would be dealing with a drug-addicted individual, often Indigenous, who would sell one rock of crack cocaine to an undercover officer. And these are very elaborate projects, lots of officers involved, observation posts. And I would go to court after they're arrested, and they would now be in my forum. This was my house, so to speak. And I had my marching orders from Ottawa, and I would seek their detention, because by the time they got to me, they already had a record that was a mile long, primarily petty offenses, possessions, breaches of bail and probation. And because their record was so long, the presiding judge would typically detain them. They would not get bail. And then they would come back to me again when they wanted to plead guilty because they wanted to get out of jail. And I would ask for a first offense, a 3-month jail sentence. And I was told, or my marching orders were, that it didn't matter what the circumstances were, their personal circumstances, how small the amount that was sold, whether they were addicted or not, whether they were Indigenous, I had to ask for jail. And what I felt quite good, actually. I was putting drug traffickers in jail. I was putting bad guys in jail. I felt really good about what I was doing. And then I started to notice something. I started to notice when I'd go into my courthouse a couple months later, the same name would appear and the same face would appear back in the docket, or the doc, I should say. And I would say, well, clearly this individual has not learned their lesson. So now I'm going to ask for their detention again. And now I'm going to ask for an even bigger jail sentence. Maybe they'll learn the second time because they've gone to jail for a longer period of time. And it would go in that cycle. So it'd go from a 3-month sentence. I would ask then for a 4-month sentence, then a 6-month sentence, a 12-month sentence. And guess what happened? Well, I would see the same name and the same face all over again, no matter how high of a sentence I asked for, no matter how many times they were detained. The same name and the same faces. And after a while, some of these individuals, even came to recognize and know me. Hey, it's Mr. Dhanu, the Crown prosecutor. Ironically, some of them would go on to be my clients as a defense attorney because they thought I did such a good job putting them in jail. So I would later represent these individuals. So I asked myself, when I look back, what is systemic discrimination? It's an institutionalized way of doing things that perpetuates disadvantage among a certain group of people. There was this whole monolithic system that I was now a cog or a part of that picked on a certain group of people more than others without taking into account their background, their history, or why they were doing what they were doing. It was a very black and white view, good guys and bad guys, the exact same mentality I had been raised with. Now, at that time, even as a Crown prosecutor, after law school, after an undergraduate degree, I still did not understand systemic discrimination. I was part of that whole machine. Even as an immigrant, I didn't get it. But I still felt something was wrong. Something wasn't right here. Something wasn't adding up. Why are these people coming back over and over? I didn't feel as if I was helping society. I didn't feel as if I was helping my fellow man. I didn't feel as if I was helping my own soul, quite frankly. In terms of my journey, the other aspect that was important to me was prosecuting my own communities. I wasn't just prosecuting Indigenous peoples, I was prosecuting members of the Indo-Canadian community. Now, I should have known something was wrong when I put all this hard work in, went to law school. I came home proud. I'd landed a job at the Department of Justice. I'm a prosecuting attorney, and I came and told my mom, and she just kind of looked at me with disappointment and asked me in the Punjabi language, so you're going, just so I understand, you're going to be putting members of your own community in jail? And she shook her head and walked away. So I think she understood systemic discrimination better than I did at that time, despite her immigrant background. And that is the tough love of a Punjabi mother. The South Asian population now does many amazing things. They're very involved in politics, business, they're professionals, farming, you name it. But what do we see in the media all the time, primarily in terms of the Indo-Canadian population? It is South Asian children who are kids, young adults who become involved in gang violence and drug trafficking. Now, not that that is not a problem in the community. It is a problem in the community, but it is the majority of what we see. It doesn't reflect the community in terms of what the community is doing as a whole. And I, like most people, even despite being an immigrant, despite being part of the community, was influenced by the media. So when I saw these kids, these young Indo-Canadian kids coming to court who were charged with drug trafficking, who were charged with possessing firearms, what did I do? I took that mentality that I took from the media and I threw the book at them. I didn't try to understand why their path was different than my path, why I was prosecuting them and why they were in cells. I simply thought, well, look, I came from an immigrant background. I'm being a good guy. Why aren't these people good guys? So what then, when I look back, is systemic discrimination to me? It's what we hear in the traditional media, what we hear in social media, what we adopt in terms of the media noise that is all around us, and how that becomes a part of our thinking and our values. And I think it's really important to recognize the influence that media has in terms of how we perceive the world, especially now in this polarized environment that we live in. So at the end of the day, experiencing all of this through my immigrant lens, I still, at this stage, did not understand systemic discrimination, even after a few years as a prosecuting attorney. But I did understand that I felt something wasn't right. And I felt I wasn't being fulfilled in terms of what I thought being a good guy was. So I left the Crown Prosecution Service and I became a criminal defense attorney. I knew something was wrong. I knew I had to begin a new journey. And I began to see clients from all walks of life, Indigenous, immigrant, every different sphere, every different social strata. And I began to look into their background. I began to learn their stories. I began to look at the root causes of why they were doing what they were doing, because that was now my job as a defense attorney. And I began to see the role that systemic discrimination played in their lives and why they were now in my office. And that's when the pieces of the puzzle all started to come together. A light bulb went on in my head in terms of how I had grown up, how I was raised, my experience as a Crown prosecuting attorney, why I left, and now understanding their stories, I began just to understand the cusp about what systemic discrimination is and how it is so prevalent in our society. And to be frank, I'm still learning each and every day, and I'm looking forward to learning from Judge Gerald Morin and Kathleen Roussel as well. And that essentially is my journey in terms of systemic discrimination. And I'm looking forward to keeping learning and doing something about it as well.
Thank you very much, Rob, for sharing your perspective from your own background and from your own experience. Kathleen, floor is yours.
Thank you, David. And of course, I want to thank Rob and Judge Morin in agreeing to participate with me on this panel. And of course, David for inviting me. I don't know if he invited me because he thought I would be a good person to speak to you, or because he was afraid I'd be miffed if he invited someone else. Nevertheless, here I am. And I'm going to focus my time on telling you about how I see the role of a prosecution service in addressing systemic discrimination and overrepresentation of Indigenous and Black Canadians. I start that with two important realizations that I think, at least the first one is widely shared by Crowns. The second one is the harder one. And the first one is this. As a Crown, the decisions that we make have a very important impact in perpetuating the status quo. And once you appreciate that that is an issue, then that leads you to the second realization, which is that we have to change. That's not to say that other parts of the criminal justice system don't need improvement. Certainly, we have, as you know, a very important relationship with police, and I'll be happy to explore that if anybody's interested in the question period. But for me, as the head of a prosecution service, I think it's important that we focus on ourselves first and how it is that we have to do things differently. When I talk about doing things differently, I really put that into three categories. The first is, and they're not really in any order, and you'll see that they all sort of need to coalesce if we really are going to make a difference. The first is policy. The second is what I would call practice, what we actually do when we get to a courtroom. And the third, I'm gonna lump in as ourselves. To start with policy, those of you who know how prosecution services work will know that we all have something called the desk book. And the desk book is there to provide guidance to prosecutors about how to exercise their discretion in decision making. In the last couple of years, we've had a group of counsel who have been working very hard on making changes to the desk book to reconcile, to realize that we really haven't taken thus far too many steps towards reconciliation with Indigenous Canadians. They have made, I think, some crucial changes to the desk book with respect to how we interact with witnesses, accused, and victims who are before the courts. And if you look, just for example, all of our desk books are public. If you look on our website, I would certainly recommend that you look at the decision to prosecute test to see how we have made important changes on dealing with Indigenous accused. That's just one example. In terms of policy, we are starting a wholesale review of our desk book in putting on what we're calling an intersectional, it's very hard to say, intersectional lens on our policies and our practice. And what that means is that we want to be making decisions that actually consider things like overrepresentation. If you look at our desk book now, other than with respect to Indigenous Canadians, you're not going to find the word in very many places, and you're going to find only the most scant mentions. And at the end of the day, we have to look at our policies with a more objective, unbiased eye, and in a manner that will actually make a difference when we go to apply these policies in practice. I'm going to give you one concrete example of that. If you look at the decision to prosecute, in considering public interest, we have a statement that says that discrimination or bias related to race is irrelevant to public interest. I want to say that that's true, and in many ways it is, in the sense that we should not decide to prosecute someone based on race. On the other hand, I think that there's a case to be made that occasionally there will not be the same public interest in prosecuting someone for a minor offense when you are dealing with overrepresentation, particularly to the extent that there are other avenues available to take the matter out of the court system. And I'll talk probably about this a little bit later, but when you're dealing with possession of drugs, you'll see that we have a policy where we now prosecute not by default, but we prosecute by exception. And that is really, in a sense, turning the former test that we used to apply on public interest on its head by recognizing that there are better areas of society to deal with what is at its root a health problem. There are other parts of the desk book that to me are crucial. One of them is our bail chapter. It's evolved considerably over time in order to ask our crowns to exercise discretion and to essentially not overload the conditions. I think that still needs some work. And very oddly, when you look at our desk book, you will not find a chapter on sentencing. You will find a chapter on how to engage in resolution discussions in a principled way. You'll find, but you don't find one about how to apply your discretion in terms of sentencing. And that's a very big hole to me when you are talking about overrepresentation. So that's the policy angle. And obviously, if you have questions about that, I'll be happy to answer them. Policies are terrific, and you need to have them because it has to be visible to the public how it is that we are intending to apply our discretion. But all the beautiful policies in the world don't translate into anything if you are not putting them into practice. So to that end, when I talked about adding an intersectional lens to our practice, that does mean training for our prosecutors. In the past, when we made changes to the desk book, we basically launched them with a nice email saying, go and read this and off you go. And we realize now that for the most part that's insufficient, particularly if we are going to be tackling things that are challenging and against the accepted practice of hundreds of years of prosecution. And so we are going to be launching a very large exercise of, I would call it retraining, starting with me in the first cohort in the next month or so, on how we make decisions and how we properly factor in things like overrepresentation and areas where we know that systemic discrimination exists. I'll give you one example of that that's very easy. When we look at breach charges of bail conditions, we know that depending where you live, you are more or less likely to be policed and therefore more or less likely to be charged. As a Crown, once I know that, I should be considering that in the manner in which I deal with those bail charges. If you look at our desk book, you'll see that we encourage our Crowns to use referral hearings, which are a new tool in the criminal code. I know that they are still Canada-wide, leaving aside the PPSC, underused. And yet we know that short sentences for breach of bail are something that concretely add to overrepresentation. So there are things like that that in practice are very easy to deal with. The legislator has given us a tool and it's incumbent on us to use them. Another part of practice that I think is important is managing our relationships better. The criminal justice system as a whole, and certainly the Crown, tends to be a little bit too insular. And it's dangerous if you are insular and only talking to the police. And that's not a slight towards the police on my part, but you are missing a whole group of points of view from civil society, from organizations that assist accused persons, and from the community. And so we are going to be investing in outreach in our communities, most particularly in the North, where I think it's important for us to understand the communities that we serve, particularly as we deal with victims very actively in the North. So there's a whole relationship part that I think has to be really reconsidered in our practice. Some of that is, of course, trying to work better with the other actors within the system, but also reaching out outside the system. Finally, I'm a big fan of being able to monitor what we are actually doing, because at the end of the day, when you make changes either in policy or practice, you want to know that they're actually being followed and that they're having the desired effect. So we're actively monitoring now how our Crowns are doing on dealing with bail charges that are laid by the police, and we're actively monitoring our simple possession policy, and that's how that's working out on the ground. And I think as we move forward and change our desk book, in each case, we're going to be looking at, is it possible for us to monitor the impacts of the changes that we're making? Finally, the third aspect is really about us and us as a service, but I think also us individually as Crowns. We have been providing training on implicit bias. That to me is a bit of an of course. You need to first admit that you have bias and be aware of your biases in order to make better decisions. But that to me is very much sort of the tip of the iceberg of what needs to be done in order to change our mentality and our practices. And a big part of that, I think, has to do with being more representative of the communities that we serve. It's not an easy equation for the PPSC. Every community that we serve across Canada is different. And so I do expect that each of our regional offices will have a slightly different take on what representativeness looks like. That said, we are also looking at recruitment differently. We have in the past been very reactive. Being the federal government, it's a luxury to be able to put out an advertisement and ask people to apply and have hundreds of applications, but that's not necessarily going to get us the people that we want. And at all levels of the organization, we have to make a better concerted effort to go out and get the people that we want and need to make us more representative of our communities. As an example, we're opening an office in Surrey, BC. And it's obvious to me that that serves a very particular community and that our office should look like that community. I'll give you another example, which is in Iqaluit, in Nunavut, where we have an office and run our circuit courts from there. It has been very challenging for us to have sufficient numbers of Inuit staff. And we were able to contribute to the education of some of our staff who elected to go back to law school. We have been able to recruit from the Inuit law school program in order to have people who will be articling with us starting this year and hopefully retaining some of them. So little by little, we're trying to change. I don't want to say the face. In some ways, it's the heart and the conscience of the PPSC in order to be more representative. Now, recruitment is a very small part of it, and in some ways, the easiest part. In many of our offices, recruiting diversity isn't difficult, but promoting diversity has been much more challenging. I'm starting to see some very important glimmers of hope, but there's a concerted effort that needs to be done for those of us who are managers of people to make sure that we are giving adequate opportunities to everybody that we have recruited, and particularly to those who are filling an important need of diversity in our organization. When I look at my management table, it is still fairly homogenous. Changes are coming, but coming slowly. And we have to recognize as managers that how we assign files today, so if Rob came back to the PPSC today and I assign files to him, what I'm assigning to him is going to dictate his career going forward. And so it's very important for us to consider fair allocation of opportunities, both promotional and stretch opportunities for our council, if we want to be representative at every level of the organization. That representativeness beyond, I think, giving us better results on the ground, also I think adds to our credibility in our communities, which in and of itself can only assist us in getting better results for public safety generally. I'll stop here. I will say that I'm finding that our staff are very open. They want to contribute. There's groundswell of excitement about participating in these things. We have various committee structures that are going now. Staff on their own with very little input from me put together a promotional booklet for recruitment campaigns. So I can see that if you propose changes, people actually want to make them. And I think that as we have more and more of these discussions, you can expect that the PPSC will continue to participate. So I will stop there.
Thank you very much, Kathleen. And I hope it's evident and obvious to all that based on the strength of your words, that's the reason why you've been invited, not out of fear for any other consequences if I had not invited you. Every single one of you on this panel is a formidable individual and has a very rich perspective. And the last, not the least, the perspective of Judge Gerald Morin. Judge Morin, over to you.
Well, I hope You can hear me? Yes. Jansen. Navas kumuna mutaga pewichian. The big Scott man with a swing. Nina vocation stotake. I'm very happy to be here to talk about law and how Indigenous people, and mainly the Cree, look at it. Wanaswain is a word that derives from the word wanasta, to set things right. Interestingly enough, wanasta, on the other side of it, also means to make a mess of things. So I think we have accomplished one aspect of that already in what we have done in law. We've made a bit of a mess because so far into the process and how long Canada has been in place, we are starting to talk about real subjects. I, of course, as one can appreciate, was not invited by the organizers to give the Caucasian point of view. I'm here to give some viewpoints of Indigenous people in relation to what justice issues mean to us. So keep an open mind. I think in my assertions today, I will go to a teaching that came from my father and probably from his father. And it goes like this: Mach na wimata means I will not go around you. I will go through you in what I talk about. So often, I think Indigenous people have been characterized, when they speak the truth in how they understand it, have been characterized as angry, being an activist, political agitators, so the audience can make a decision to tune them up. I ask you not to do that. Because if we are going to talk about tough subject, and racism is a tough subject, it is the type of thing that when you put that on anybody, it affects their being. It affects who they are and really questions their belief system and the inner core of who they are. But we have to have these tough discussions because people have suffered as a result of those decisions, as a result of racism being practiced throughout the system, either directly, indirectly, or as a result of not knowing any better. We are all guilty of that to a certain extent. And I will say that when we look at another point of view, I'm going to premise some of the words I will talk about that I'm not going to give lessons on the division of powers and how courts are expected to interpret the law. Or as the fisherman's son on the Supreme Court of Canada says, to make law, that judges can make law. I thought that was an interesting statement. But let's examine a few of the things that we have described as being either systemic discrimination, which is often described as patterns of behaviors, policies, or practices that are part of the structures of organizations and which create or perpetuate disadvantage for racialized persons. Indirect discrimination happens when there is a policy that applies in the same way for everybody, but disadvantages a group of people who share a protected characteristic, and you are disadvantaged as part of that group. If I go back for a moment and think in terms of time and what decisions have been made, one of the more gross inequalities that have been articulated in law is back in 1973, when the Supreme Court of Canada dealt with Laval. Laval, of course, was an Indigenous woman who had married a non-Indigenous person and she lost her status. Now, along with all the descriptions and all the discussion that it had with divisions of power, one of the things that resonated in that particular decision was to say to Indigenous women throughout Canada, you are not being discriminated against, as it means within the upcoming discussions on equality later on, but you are being discriminated and therefore treated the same as every other Indigenous woman, and therefore you are not being discriminated against. Well, at the end of the day, that was major discrimination. Of course, we all know what the history of that is. The International Law Forum said, this is unacceptable, this is discrimination. But as a result of that, we then saw the clear message to government, who of course makes law. They write the laws, judges interpret the law, and in some cases make law. What has happened as a result of that, of course, is new regime of statutes that dealt with who an Indigenous person can be. If I said to you, in terms of my understanding of who I am as an Indigenous person, I'm a 6'2". They wouldn't mean much to most of you. What is a 6'2"? Well, in the Indian Act, it sets 3 categories of Indigenous people: 6'1", 6'2", 6'3". That is a pretty major discriminatory practice that Parliament has set out. It has created a whole amount of litigation and has taken the time of many to try and straighten out and deal with the federal government at all levels of court, and certainly in the Supreme Court, to keep dealing with this issue of who is an Indigenous person. Because by creating that statute, I dare say, is one of those statutes that is genocide by legislation. At some point in time in the future, there will be no Indigenous people in relation to that definition. If we are to have reconciliation, we must look at that. How do we look at it? Do we rely on the courts? Do we rely on different systems? Because if we do rely on the courts, are we ever going to have a voice on that court? We know that there's been a lot of discussion in the last while about, isn't it time that we had an Indigenous person on the Supreme Court of Canada? Well, it's not about time. I think it should happen. However, with the changes that have now occurred, and I've looked at the Supreme Court of Canada Act, I've looked at the different changes that have been made, and then the recent introduction in 2016 that all jurists on the Supreme Court of Canada must be bilingual. When you move the goalposts and you narrow the playing field and you narrow the goalposts, not only move them, but narrow them, you are eliminating a certain group of people to participate in that particular process. So if I look at it and say, we have a long history together, and yet we also have a very short history in terms of reconciliation. We became, of course, wards in relation to how we have been viewed by statute. Way back, I think as far back as 1873. We did not have a vote in the Canadian system until 1960. As Indigenous lawyers, there was very few, because prior to 1960, you would have lost your status if you became educated to the point of being a lawyer. So to get educated, you would lose your nationality. Who else is asked to do that in Canadian society? Nobody. Nobody. Yet that was the practice. And so when we look at that, and start looking in the 70s, for instance, and the amount of participation of Indigenous jurists in Canada,
It's 12 o'clock.
to say the least, there was only about 3-4 practicing lawyers back in the early 70s. Since then, it has mushroomed in relation to the number of Indigenous jurists at all levels. That is probably over 1,000 now. But you know, back when the rules were made as to who could be a judge, for instance, it took as little as 3 years in practice, went up to 5. Now it's 10 years. And even the Supreme Court of Canada, it says 10 years to be in good standing. But that added component came in 2016. That has effectively eliminated a good portion of people who would otherwise be outstanding in dealing with law. And if we look at how that history was in the Supreme Court, they didn't need to be able to speak French fluently for the longest time. Interpreters were good enough. They could learn during the time that they were there. Now, from an Indigenous point of view, our numbers have meant that changes will be made if we are going to be participating in this particular process, to our detriment. As I said, they've moved the goalposts. It makes it harder. When I think back, what was French to me? Well, French to me, in my way of understanding, my first words of hearing what French was, le sauvage, the savage, Chafou. Who did that come from? That was my understanding of what French was. And just to give you a point of view of how we as Indigenous people look at who our partners are in Canada, we describe English-speaking people as Aganasiwak. Aganasiwak is a word that describes the English. They speak Anglican. That's what Aganasimu is. You speak Anglican. Whereas the French, Mistigosho. Mistigosho comes from the word, the ones who paddle the York boats, wooden boats. That's who it is. We have a true understanding of what it means to incorporate language as a major piece of who you are. We at one time were at the table, I think probably when the Charlottetown Accord was being looked at, and we came close to being able to incorporate Indigenous language as part of the Constitution. That failed. When I think back in terms of other failures and how we could really become partners, some of what I said before in relation to how we are often viewed when we look at trying to either indigenize the process or trying to put ourselves in a situation where we are meaningful participants and not just recipients of a service. We want to be part of what is being done. We cannot keep being pushed aside. Every day, people make rulings. Every day, people make changes. And I know the inherent limitations to a certain extent of what we as judges can do. I think that's the first thing I learned as being a judge, is to understand my independence, but at the same time, the inherent limitation of who I am in what I do. That was so clearly pointed out again in a process where a government made laws that we were expected to follow of mandatory minimum sentences. That was a form of very direct discrimination, very direct, also indirect discrimination. Because again, we are everybody's being treated equal, was the message. If you do this kind of crime, we will not take your individual circumstances, notwithstanding what Gladue and Ipili said. You will follow the regime of what is placed before you. Well, again, it elongated a process where sentencing could occur to try and put Gladue factors because the minimum sentences were getting in the way. That was another lesson as to how we were being pushed back and how our participation was minimized as to being a mere recipient as opposed to a meaningful partner to look at an individualized process and to incorporate what we believe to be important things as rehabilitation and perhaps looking at those type of avenues as to reconciliation, how we can make peace with each other. We criminalize a lot of social problems, and by doing that, we of course increase the number of people that are caught within that web. When we talk about in statistics today of how many people have been in jail, how many people are going through that process. We look at drugs, we look at mental health, all those factors we have criminalized in how people are dealt with. So not only do we need to participate in all levels of court, including the Supreme Court of Canada, and really question what is the real reason for the movement of the goalposts. Does it make them better judges? Because they can speak French and English? I understand how important language is because it incorporates your culture. It clearly illustrates who you are as an Indigenous person. And the same way with French. They bring in their culture through that language. But if you learn it as a second language, it doesn't incorporate that type of understanding. But yet, that rule has now been made. What's the real purpose of that rule? Is it no longer good enough to have interpreters in relation to the Supreme Court of Canada and those who might learn that language during the process? Or is it served to eliminate again some people that might be very good jurists, but for the language factor? That in itself is something that we need to understand. Another thing that I think I want to touch on is a bit about some of the things that we have seen in juries and how that perhaps we need to have a better understanding as to how we select jurors. One of the things we have often heard, at least in Saskatchewan, is that names are picked out and they will use things as health cards because it doesn't really identify who you are. Well, one of the things that people don't realize is that those health cards do identify who you are. If you are a Saskatchewan person looking at this particular video right now, and if you have your health card, if you're Indigenous, treaty, take a look at the bottom. It has R. Your non-Indigenous friends that are lawyers will have a number. You are easily recognized by the R as registered. Now, is that so anonymous? Do all people know that? I don't know that, but it is easily identifiable as to who is an Indigenous person. And yet they say that is one of the ways that we can make sure that we don't know who we're picking in terms of juries. Juries are, of course, very important. We look at different things. I listened to Madam Justice Martin in her speech about impartiality and juries in relation to a recent speech that she gave at the College of Law. She said some very important things. One of the things that she was suggesting was to look at and think about this. how many times as we individuals heard other people say derogatory things in our presence where we did not intervene in any way? I'm one of those. I've heard certain things said. I did not intervene at that particular time. Put it for later. Didn't want the confrontation. One of the things that Madam Justice Martin says, she says, you know, one of the directions that might come from a judge is to tell juries that if they hear somebody within the jury room starting to talk about the negative things that might be about this particular person and what their beliefs are and what their lack of education has taught them about Indigenous people, that they should speak up. How intimidating do you think that process is for a juror? And yet we have that expectation of jurors who deal with somebody who is espousing maybe some thoughts that they believe are true, but are really not true because they're based on erroneous information and a lack of education of who we are as Indigenous people. But this is what they believe. Education got us into some problems in relation to residential schools. To some extent, education will get us out of this particular process. But we must be ready to tackle it on the basis of questioning. And I think one of the more profound things that Madam Justice Martin said, we must not only question ourselves in what motivates our thinking, we must interrogate ourselves. We must interrogate our beliefs and what motivates. That to me is a better level of thinking of who we are and what it is that we base our beliefs on. It's a interesting thing to look at and say Supreme Court of Canada and our involvement as Indigenous jurists to be there at some point. But I think one of the other things too is that we need to create and recreate what we had from 1970 something. I'm trying to think of the year when the Law Reform Commission was first started, but it had a bit of a burp in 1990s, and then the Harper government got rid of it in 2006. Well, the Law Reform Commission is one means of maybe revisiting some of these type of issues, to look at having a robust Law Reform Commission, to look at the question, for instance, why can't Indigenous scholars who continue to write and explore Indigenous legal concepts and different schools of thought, how can we incorporate some of that thinking to make sure that it is there, that it can make some changes? We all know that the Law Reform Commission made major changes in the family law delivery system. They incorporated a lot of what the Law Reform Commission wrote about family law and family law hearings. That can still happen in relation to Indigenous issues and major issues dealing with how we look at juries and include Indigenous legal scholars or just Indigenous people to deal with some of those issues in a Law Reform Commission basis. Because that is another avenue that we need to explore. Don't exclude us, include us, because we have some solutions. We just need somebody to listen. Thank you.
Thank you very much, Judge Morin. As announced, none of you were in a position to be for want of words. There are some things that were mentioned already by you, Judge Morin, by Rob, that related to language and use of language and how it conditions individuals, how it reflects reality. And we have two comments from the audience on this. So I'm going to put that on the table to see if that's something any one of you wants to embark on, and we'll also put another general question to you to get the discussion going. And by all means, grow from that discussion and exchange within one another. One aspect related to language is how it can condition us. You mentioned how Western movies were characterizing the bad guys and the good guys using language that at the time was very much in usage, but conditioned generations of people to see the world and in a way that is not consistent with reality, but really foster a certain view of injustice, creates it. Judge Morin, you also mentioned the derogatory use of the word to describe Indigenous people in French, and how this has an effect, and how as well how people are addressing issues in presence of others, how it shapes the general dynamic. Slightly related to this, a question that was posed is that opening to views on the different understanding of certain concept in Indigenous language, for example. If there's a difference when we say in French or English, concept of telling the truth, the whole truth, nothing but the truth, and guilty. Is there an obstacle in terms of language and understanding those concepts, which may not be known or intentional or perceived from the actors in the system, but as a very concrete impact? That's a general area if you wish to explore. And the other one would be on the general level, what would be, and we've heard from you, different obstacles. What would be one of those obstacles? I would say this is one of the ones that we need to tackle within the system, within its rules, within its proceedings, that could benefit, could lead to improvements. So I'm leaving the floor open to any of you. Signal your intention to speak, and the floor will be yours.
Well, certainly I can start off, and I'm sure Judge Morin will have more to say as well. So when I was a prosecuting Crown attorney, I was also on the Yukon flying squad, so flying in Yukon territory to remote Indigenous communities. And I felt, first of all, like a bit of an imposter, I'll say, in that I was there to deliver the so-called white man's justice. And when I would get off at the airport, they would see this brown person get off the plane. And I felt like the Indigenous community thought that perhaps the government of Canada had outsourced even the white man's justice to India. So when we would go there, unlike, I see Judge Gerald Morin appreciates that. When we would go to these communities, unlike what we have here in Vancouver, where we would have charter issues being raised by defense counsel, we would have drug trials that would stretch on for days because numerous defenses were advanced. I would deal with a lineup of guilty pleas as a Crown prosecuting attorney. There were no trials. Every individual was pleading guilty on that docket. And when I spoke to the duty counsel about it, and I spoke to some of the locals about it, it came back, and Judge Gerald Morin, he'll be able to provide more context and for more depth, but what my understanding was that there's this process in terms of reconciliation, in terms of dealing with hurt and harm. There's this process of admitting your guilt in Indigenous culture. And so all of these defenses that would be advanced in other jurisdictions simply were not being advanced. And as a result, you would have individuals who should not have had records for certain offenses who had records, and they were piling up because of this process of admitting one's culpability due to cultural reasons. I'm sure Judge Gerald Morin can expand on that.
I can see that Kathleen has her hand up. So Kathleen, if you wish to say anything on this topic or anything else, and Judge Morin afterwards, if you have something to add.
Yeah, and part of what I want to say, I'm hoping Judge Morin will also address, there's language in terms of spoken language and expressions and what things mean. There's also always the issue that I think many of us sometimes underappreciate, which is you know, as a French Canadian white woman, I'm a big believer in reading body language, and in my culture, body language is a thing. But I do appreciate that when I'm dealing with people from different cultures, and certainly particularly the Inuit or various indigenous cultures, body language is something that you can't read in the manner in which I'm accustomed. And I think it would be interesting for Judge Morin to address that as well, because it's always a very dangerous thing with a jury who may be tempted to interpret things that really are meaningless because it's just how they interpret things. But so just Judge Morin, if you'd address that as well, I think it would be interesting for people listening in.
I think one of the things that I learned a long, long time ago is that people do misinterpret people with English as a second language. They will say that they were reluctant to answer a question directly. Well, when you're sitting there listening to a question in English, you hear it in English in the manner that you can, to the extent that you can, you then interpret that into Cree. You then think of what was said in Cree and how you interpret that in Cree. Then you formulate an answer in Cree, because that's how your first language works, and you think in Cree. Then you go through the next step of trying to answer in English. That takes a spectrum of time. You are then being judged as being reluctant to answer a question. How many have been judged through that particular process? I think in the years that I've been involved in doing trials in Cree in the First Nations communities that I was involved in, that certainly eliminated that portion of it. But then one of the other interesting things, just to move from there, so that's a process that people go through. They're trying to understand what's being said to them. They're trying to formulate an answer. Then they're trying to interpret that back into the language that is being used predominantly. Then we get into a situation why, as Rob says, you had a lot of people that were pleading guilty. One of the more interesting presentations I heard in the last while was my Mr. Justice Tony Mondamin. Tony Mondamin discussed the issue of when he practiced law, and he says, very seldom did I deal with things in trials, he would say. I would deal with people taking acceptance for a portion of what they did. The added portion to we as lawyers needed to do was to really question that guilt as to merely the act. As we as lawyers look at actus reus mens rea, incorporate that thinking into your question on where that person was coming from. Very number of times you would find yourself starting to get a discussion on the other areas of mens rea, which goes to those particular things. But if you don't take that time, you will take the first notion sometimes as accept a guilty plea on that basis. But there is very much a process, and that thinking is not the same. So those are things that I have certainly looked at over the years, and language does play a major role. And the issue also of saying, I have done wrong to that extent in the actus reus, and therefore I am guilty in relation to that. And that's the guilt that I talk about. And so that's part of the process of reconciliation of why I did it becomes also part of that discussion later. So it's a different way of looking at what we have learned as lawyers in trying to make some peace between people, in trying to reconcile their differences and how one has hurt the other. So certainly it is very much a big factor. So.
What role, what place do you see, any of you, in terms of individual education of the actors within the justice system, maybe starting with law school, but maybe even before that, but to try to overcome some of the built-in obstacles in the system as it exists now, to bring us to a place where these issues are addressed and the system is improved. Any views on this?
No, absolutely, David. Now, just as I indicated in my discussion, we are educated and taught at such an early age about the world around us that we really have to then go back and unravel this tight ball of yarn that makes up our values and our worldviews. And I really think that, can you imagine an individual has an undergraduate degree, who has gone to law school, who is a Crown prosecuting attorney, and still, with all that education, with all that experience, still does not understand what systemic discrimination is, until he really has to delve into his entire background, his entire upbringing, his entire worldview, to try to tear it apart and rebuild it. It was really a process and a journey for me, and I think it would be very important that at some stage of the educational career, and the earlier the better, that we begin to address these issues and deal with them. Because imagine an individual, you can easily go through your whole life without ever even thinking about this issue, or perhaps acting out in a way that increases systemic discrimination rather than assists in any way.
Thank you, Kathleen.
I just want to say individual education is nice. I think collective education at this point is actually more valuable, whether it's collective, within my service, but I think even more valuable are the opportunity to speak to other interveners in the system, or alternatively to civil society. And I say that because as you educate yourself on issues of systemic discrimination and your part in it, it's important to have someone there who can give you point, counterpoint, or challenge some of your views. And if you are solely educating yourself, you take a few bias tests, very useful things to do. I think once you go beyond that, you really do have to learn together and be able to challenge each other, because what we are trying to do is rethink every decision that we make and how we make it. And I don't think that you can do that on your own, sitting in your little silo. In the same way as I think that the criminal justice system has to start letting in more people from the rest of society, including health officials, among others.
I will just mention something in relation to this. I came to know Judge Morin a year and a half ago. One of our colleagues who knows him introduced him to us, and then he spoke to the group of all the senior management at the PPSC, and I learned a lot there. And through conversations with Judge Morin afterwards, and including him pointing out to a lecture he gave to university, to law school, I'll preach it. I've learned facts that I did not know that changed my outlook on many things. And just as mentioned earlier by Judge Morin, the fact that the right to vote for Indigenous individuals at the national level, the federal level, without losing status, only came in the 60s, not 1860s, 1960s. And the correlation between that and, strangely enough, the overrepresentation, at least in the prairies, starting at the same point. And that aspect and the lived experience of some of the rules, how it affected Judge Morin's family, it just changes your perspective. Says, wait a minute, we have Canadians going into the system, which apparently seems to treat everybody coming in the system in the same way, but everybody's not coming from the same place to start with. That's the system. And I think today is an opportunity, again, to outreach to the tens of people, 100 people we have today attending. So Judge Morin, I don't know if you want to expand on this notion of education and outreach and providing information and lived experience to change views, change the hearts of people, so then they can act in a certain way consequently to that.
Thank you. I think one of the things that, to start off on the education aspect, it's very, very important that law schools, and I think law schools through the recommendations of Truth and Reconciliation have been told in some ways, and through also the Royal Proclamation, Royal Commission said, we need to have Indigenous education programs within law school to be mandatory, either in the first year, second year, or third year. Well, I know for a fact through a lecture series I started a number of years ago, we brought 3 speakers, all women, who made great recommendations. And I know that the College of Law incorporated and now have in College of Law in Saskatoon, in the upper law program, they will need to take mandatory Indigenous studies a number of hours. That was never there before. That is a start in that particular process. I think some of the experiences, to go back to some of those questions that you relate to, some of the major impacts that I always felt that I was never a minority until I left home at the age of 16 because I had to, because there was no high school in my community. That was 1969 when I had to leave for high school. All of a sudden, I am now met with my neighbors and people, and you learn pretty fast at how you are being looked at. And so often throughout my life, I would get called chief, big Indian, all those type of things. And sadly to say, even as a judge, being told by another judge, how you doing, chief? You know, that type of thing. Sure, you get thick-skinned about it, but you say to yourself, education will help you. I learned a long time ago, I think probably that diplomacy was better than the fist. I had to. Otherwise, we know where I would have ended up. I would have been seen as angry. I would have been seen as this and that. But you learn to deal with those type of things. And yes, education is our answer. And how we try and deal with those type of problems that confront our people every day at the street level. When I said before, we have criminalized a lot of things. That is the things that we really need to look at. To look at whether or not those are true criminal activities. In Cree, in the Cree worldview of things, we had Higitimaksit, Isasipitak, Imatsatsit, 4 different types. You say, Isasipitak is a word that means one who does not listen. Never listen to his parents, never listen to his teachers, never listen to probation officers. He goes about his own way. Is he the true criminal? Or he just needs to grow up in certain ways? Is that a true criminal? Iktimaksit is a person who has been caught up in certain ways of his lifestyle that they have now become addictions. It's overwhelmed him. It's undermined his ability to do certain things. Is he a criminal? Or is he having to deal with all things that confront us on an everyday situation, and he's not quite sure how to deal with those? Are those life skill issues as opposed to criminal issues? Deal with addictions. Iktimaksit is another one that we look at and say, is it a person who has lived a good life for a certain period of time, gets inebriated, gets in a vehicle, kills somebody? He is now going to truly suffer the consequences of the minimum sentencing regime and all those type of things. Is he the true criminal? Or has he made a major mistake that can somehow still be reconciled? But we know how society looks at it, and there's reason for that. But we need to look at those issues. And how many have I dealt with in my career as a lawyer or any lawyer? Imatsatsit, the true evil one. Yet we have made many laws based on the evil ones, the Paul Bernardos of the world, the Clifford Olsons of the world, and those type of people. We have made laws to try and fit everybody else within that framework. We need to really take a good look at some of how those laws affect. And so, yeah, there's been major changes over the years. I know my family has been impacted by the Laval case, for instance, those type of things. And maybe some of those discussions for another day, because I'm taking up too much time, but I know there's many things of that, and I will end it there. Thank you.
I will group two questions from our audience together. One is specifically for you, Judge Morin, but the other one being combined is opening up. So the question is, and it follows straightly from what you were saying, we're discussing, is there an example, a specific example that you can come up with of someone to take responsibility for something, but that would not necessarily equate to criminal responsibility from a legal perspective? And associated with that in a more expansive way is it possible to incorporate Indigenous values, some of which you describe in concept, into the existing legal system that we have, or do we need a parallel system? So the first, again, to you, Judge Morin, but then the floor is open to Kathleen and Rob to contribute to the discussion.
Somewhere in the hollow corridors of my mind, I'm sure there's an example in relation to one who's not truly criminally responsible. One of the teachings that we have in terms of different things and how we should look at things, I would often see situations where, for instance, and just leading to an answer, but I would see women being caught up in a situation where they would have to testify against the person who has hurt them, domestic violence, okay? And then I would always say to them, if they did not testify, that that was okay, that there was nothing wrong for them not testifying, but that it was important that they call out for help at any given time they needed to. Because sometimes that's all that is needed to stop a situation, and they should never shy away from being able to call for help. And then at the same time, you see young people who have a mixture of traditional teachings and then get caught up in a domestic violence situation. And they know what they have done wrong in relation to certain things, but what provoked it, what started it, what incorporates might be self-defense in some situations, but they're feeling so bad in relation to a certain thing is that if they explored what the defenses are, they would be there and they will still plead guilty. Because one of two things, they will find themselves in a situation of, if they're in a remote community, of possibly being held without bail, being removed from their community, being taken away. Do I go through that process? I have very often had discussions with people wanting to plead guilty, and I started asking questions. There was always a problem for some lawyers when I started asking questions. I would ask questions in Cree. Why are you doing this? Are you truly doing this? No, you start hearing the different explanations because they come more freely. So yes, I've seen those type of things. Expediency, the teaching that they've been told. Yeah, you did the physical, but is it true guilt in relation to looking at what some of the defenses might be? Expediency is the biggest culprit of all those things. On the second system of parallel systems, yes, I've often looked at this, but you know, I think there's room that we can still do things here. Let's exhaust all our possibilities, but not at the expense of more of our people being lost. We need to be more demanding in relation to what role we play. But I think we also need to build up some of those factors in that we can actually do parallel systems in our communities now. We can do that now in terms of developing a more robust sentencing process, and to be demanded by our own people within the community and have them play a role in that process and usurp some of the process that a judge will go through in looking at sentencing people. We can start doing those type of things now. And if that means saying a parallel system to a certain extent, we have to start somewhere. Why not there? So there's room for different avenues and maybe a marriage of the two, that we have ways of dealing with certain things and we can incorporate them. And if they're not going, if the system is not going to listen, then maybe we still do it. So there's room either way.
Rob.
Yeah, so let's follow up on that. And the question of parallel systems is probably too big a question for us today, but I can say that there is a need for more understanding, more context, more advocacy when it comes to Indigenous offenders. I can say from my experience as a prosecuting attorney, it was too often when sentencing came around that all we would learn about the Indigenous offender was their name, their age, whether they had an addiction or not, and whether they had any work history, and that was it. And you would sentence them and send them away. One of the greatest tools that I discovered, and which is still underutilized despite GLADU, despite IPV, is the GLADU report. There is something so powerful when you have a member of the Indigenous community go back and speak not only to the accused individual, but their family, their elders, community members, and then you bring that story and that background to the court and advocate and explain and provide the backdrop as to not only who this individual is, but why they are doing what they are doing. And I know I can count on my one hand, there's been 2 occasions where I've actually become, as an advocate, as a defense attorney, emotional in court to the point where I could not speak my next sentence. Both were in relation to having GLADU reports read out loud in the court and hearing about what this individual who is now before the court had gone through and the road they had traveled and why they were there. And oftentimes I would have offenders who were 50, 60 years old who had records with dozens of convictions and had never had one GLADU report done until we ordered it for the first time. And it was for the first time that his history was brought to bear before the court. And the results were absolutely amazing. You would have to be heartless not to be moved by these reports. And the impact it had on sentencing would be to cut the sentence in half, by 2/3. Very impressive results. We need to advocate more. We need to have that context, that storytelling, which is so much a part of Indigenous culture in our courts.
And again, for everyone, including Kathleen, to what extent a true implementation of the principles outlined in GLADU, and despite the existence of GLADU, we know that overrepresentation has continued, has increased. But a true incorporation of those principles in action, and potentially extending that to other segments of the population, because other individuals come with their own environment with them that equally shape. There may be different conditions, but that also shape their actions. Why are they not more used? What are the obstacles, and how beneficial could that be within the system? Opening the floor to any of you.
Absolutely, and I'll follow up on that as well. I think it would be, I've actually thought about this myself, not only GLADU in the criminal context, but GLADU, my wife is a family lawyer, GLADU in the family context. it would be very valuable. And then Gladue outside of the Indigenous context in minority communities to understand. I've had clients who have come from the Sudan, who have experienced years of civil war, who were child soldiers, who are unbelievably mentally scarred and will have PTSD for the rest of their life, whose families have gone missing and they have no connection. A Gladue report would do wonders in terms of explaining what this background is, the cultural context, the historical context as to why this individual is doing what they're doing, and why they're not happening is simply resources. Why are Gladue reports not being used to the extent that they should be, even though it's our Supreme Court has said that any Indigenous offender should have the value of a Gladue report in their sentencing. It's simply resources. Oftentimes it's underfunded legal aid who has to fund these Gladue reports. The courts aren't doing it. The government is not doing it. It comes down to a question of money, unfortunately.
Kathleen.
Well, I don't disagree with anything Rob has said. I think Gladue reports are important, but I think we have to think a little bit more broadly. The reality is resources are always going to be an issue, and Gladue reports come at the point of sentencing. And I think in a lot of instances, and Judge Morin spoke about this, about what we choose to criminalize, some of the resources, instead of putting them into sentence reports, really we have to look at putting them into alternatives to prosecution. And in a lot of cases, I've said in a lot of various places, I'd love to divert this person, but there's nowhere to divert them to. And so I think we have to start with a rethinking of what needs to be subject to a prosecution. What are the alternatives to it? And then in the cases that really do require the prosecution, then look at better outcomes in terms of sentencing, which includes Gladue reports to the extent that there are sufficient resources to do them well. And, I know in Nova Scotia, they've been piloting similar reports with respect to Black Canadians. I think there's a lot of scope for that. But at the end of the day, to me, that's a bit like, trying to close the barn doors after the horse has already run out, because it starts with making choices about what we prosecute and what we can divert out, either to the health system, to the housing system. We have to have a bit more of an approach than just worrying about sentencing, which is important, but not, I think, to the detriment of the other parts of it.
Absolutely. I agree with Kathleen. Absolutely. So in terms of individuals who begin to accumulate a record, it happens very early. It happens when they're youths. And then it continues from there onward. So as long as we are trying to implement an approach that looks at the system from the beginning to the end and is not reallocating resources, where resources are allocated at each aspect or portion of the system, beginning, middle, and end. I think that is, of course, would be the best approach. But once again, it comes down to dollars and cents, and that is ultimately oftentimes the real issue.
One of the things that I looked at in the process of mediation was to question the prosecutorial stance that mediation can only occur once. I always used a bad analogy of saying even baseball has 3 strikes and 4 balls, but yet we seem to think that we give one person one chance at one occasion, that it will be the end all. But no, it's a process. It's a process of planting a seed. It's a process of taking another look as to what you have done since the last time you got this chance and where are you going now. If it's the same type of activity, where is it that we need to still change and look at things differently? So I always said this should be reconciled. If it's between family members, even more push that there should be peace made and not have the imposition of an outside system to determine one side is guilty and one isn't, and we haven't solved anything. We fly off again. So when I look at that, I say that at that beginning, not only in terms of the police diverting stuff. I think prosecutions really need to take a look and say, maybe this again is another occasion where mediation can work. Is that going to have more lasting effect? Or is it so important that we have another notch on the place where people have records and it counts against them? So those are things that I looked at very hard in Cree Court, and I would always question. It was never the big project to make a difference in Cree Court. I looked at how people are in poverty, and just not having a license was a major thing. I learned how SGI worked. I learned what they wanted to do. I would always ask people, how do you get your license back? They didn't know. But when you live in a society to which there's no public transportation, how do you get to work? How do you get to school? All those type of things became major for people in poverty. So you try and get them into a situation where they get something back. And getting a license is not much for the average person like you and I and all those people listening right now. But put yourself in a situation where you have no access of anything else and just getting your licensing back. I've had people come to me and say, Judge Morin, you helped me get my license. I always say, no, it wasn't me, it was you. I have 2 jobs now. That's where it makes a difference for the smallest things. It's not the big projects that made a difference. It's building a person's dignity. And it might start from the lowest level, smallest level, but dignity of a person is very major in anything we do. Thank you.
And I would venture to say that the judge may play a big role in that, but so can the prosecutor, so can the defense counsel. There's a question for you, Judge Morin, and it's in relation to the case, the recent case of the Supreme Court in Des Hôtels. And the question, and I'll quote, the person who has the question quotes paragraph 86, which states, and I quote, "In my view, the authoritative interpretation of Section 35(1) of the Constitution Act 1982 is for the courts. It is for Aboriginal peoples, however, to define themselves and to choose by what means to make their decisions according to their own laws, customs, and practices." And the person who has the questions ask for your take on this. What do you think the Supreme Court of Canada is saying here?
Well, once you set the parameters as to how something might occur, then they are saying they have the last word. And how will they listen to what is being articulated by people to saying this is what is going to work for us? And so when I talked a bit about that process of a robust law reform, I think it's to take a look at questions like this and to really set down what does it mean, because we have the United Nations rights that are been articulated to be set in a certain way, and it sets some parameters to which are not necessarily acceptable to the larger Indigenous community, and so it's causing some problems within that group. So for authoritative interpretation, how to define ourselves, what are the perimeters and how far will they allow that? I think those are the real questions that need to be looked at. It's one thing to say it in those terms. I think we need to question some of those and say, elaborate more. What do you mean by this? What are you willing to look at? What is on the table? What are you really saying? I think a law reform commission process can do that to a certain extent, but with Indigenous scholars playing a major role, and how they bring that knowledge and how they accumulate some of those discussions at the community level in terms of either with elders or otherwise, I think those need to take place. It takes some time, but we've only been in the process for a short period, and we have made changes. I think we can do it. I'll leave it at that.
Thank you. I've got a question for Kathleen. We heard from Rob in terms of his journey. what brought him to change his career path as a result of his realization that there was something wrong, and he wanted to play a role to, a different role to address this. We've heard of the things you've set in motion within your organization. What's the genesis of that? Where does that come? What prompted you to address those things and try to do things the way you're doing them right now?
I don't know that I could say that it was necessarily one point in time or one moment. I think you evolve over time. I've gone in reverse from Rob. I started as defense counsel and ended up in the Crown's office here. I don't think it was one moment. I think, though, for the PPSC, while we were doing things, we were not doing them very publicly until this year. And I think that the events over last summer, seems like last summer anyway, with respect to George Floyd, the groundswell of emotion, not just in the PPSC, I think in the criminal justice system generally, just made us think as a management team, and it's not all about me, that we have to be a little bit more public about what needs to be done, what we're doing, what needs to be done, the way that there is to go. And I think the way we look at it is if we don't speak, who will? So we just basically went from some strategies that were sort of maybe a little bit loosey-goosey to we really have to make more of a concerted effort and really recognize the importance of our part in it. I've been saying to our School for Prosecutors for years now that your decisions largely condition what will happen in court. That's true with overrepresentation. And so I think the timing was there for us to really put a push on it at this point in time. And I think the will is there on the ground to do it.
Just dovetailing on that, Kathleen, what do you think about the role of prosecutorial discretion and systemic discrimination and that one-size-fits-all approach? Because when you're sitting in Ottawa, obviously it's a very centralized system as opposed to provincial Crown prosecution offices, and we're sending these marching orders out. And one of the things I really chafed at as a prosecutor was getting these directives, which didn't really apply to the downtown east side, and having to follow those through. What role do you think increased discretion, or is there increased discretion? What's going on there?
I do think when we're looking at things like sentencing and bail, there is an expectation, at least on my part, and I think most people understand it, that it can't be one size fits all. You really do have to craft the solution to the person who is in front of you, understanding where they have been and where they're going. And so this latter idea of every time you commit an offense, you get an extra 30 days really doesn't work, and we have to stop doing that. David's hand is up. I think he's going to tell us to stop talking.
Well, it's not so much telling you to stop talking, but acknowledging the passage of time, the one commodity that is not renewable. We've almost spent 2 hours together. And I must say, from a very selfish perspective, when putting this panel together and having the discussions, this is the kind of conversations I wanted to hear and wanted to have. And I just extrapolated from that other people would like to hear and see that. And hopefully we don't see our public, but we know our audience, but we know they're there. Hopefully they will join me virtually in thanking you and being appreciative of the discussion, which is one of thousands of discussions that need to take place across functional lines, if you will. And with more people being involved and being able to hear, open their hearts, open their minds, open their spirits as to what can be done. Not one conversation would solve everything, but if there's no conversation, nothing will be solved, that's for sure. So I want to thank each and every one of you who took the time today to speak to our audience. For everybody in the audience to participate in this event, we will welcome feedback in the ICJ. I'm reminding you of the event that will be focusing on the correctional end of the spectrum, if you will, of the legal criminal justice system. That will be taking place same time on May 17th. So those of you who are registered will receive the contact information. Those of you who are not registered, I encourage you to do that and spread the word to your friends and colleagues. So yes, thank you. We're almost at 3 o'clock Ottawa time. We're about to close. I'm David Antonyshyn, and on behalf of the ICJ Canada, I would like again to thank you very much and try to be an agent of change, positive change within the arcs that are yours within what you can do. Thank you so much.